the recent bill that we've tabled on gender-based violence and on exploitation of kids, there is a significant number of those cases that are being thrown out are involve rather charges touching on sexual offenses and sexual assault. Given the challenging nature of adducing evidence in those trials, given the very complex nature of the applications that come before the court, they often take a significant period of time. Resources is part of that equation, but process is also part of that equation. We are going to be streamlining the process of bringing forward evidence, for example, where we know the conclusion is likely to provide relevant and material information, or we know that it's not likely to. For example, with the introduction of people's therapeutic records, which would also discourage potentially victims of sexual assault from seeking therapeutic help, which is not an outcome that you want to promote. In addition, we are changing the rules around how time is counted for the purpose of that Jordan decision to ensure that certain applications don't continue to see the clock running that could contribute to delays that will lead to a case being thrown out rather. And finally, we are actually directing the court to consider remedies other than a stay of proceedings should the timelines be exceeded, because it just doesn't feel like justice to me to have the survivor of a sexual assault live in the same community or even the same neighborhood as the perpetrator, not because they've been acquitted at trial, but because the process took too long. That is not fair nor reasonable,